I thank you everyone for joining us today, and my thanks to IIDRC and MediateGuru for inviting me to moderate this panel. I have to admit that I have the easiest job of the day because I get to introduce you to this distinguished panel, and then, like the audience, I get to learn something. So, without much further ado, please let me introduce to you your panelists for the day. First up, we have Dr. Mukul Shastry. Dr. Shastry is an experienced legal leader with 20 plus years of in-house counsel experience across infrastructure, corporate, compliance, and dispute resolution. In his current role at Cube Highways, he advises on legal strategy, PPP infrastructure projects, contract and claims management, arbitration, and regulatory compliance. He has also previously worked in legal roles, including at the Reserve Bank of India and other corporate platforms. Dr. Shastry, please join us on stage. Next, we have Mr. W. Patrick McPhilamy III. Patrick is an experienced international ADRs practitioner, accredited as an arbitrator, mediator, and ODR specialist with practice spanning civil, commercial, and intellectual property disputes. He holds advanced legal qualifications, including an LLM from the University of Cambridge, and serves in roles including ambassador for the Arbitrator Intelligence and senior fellow at Bali International Arbitration and Mediation Center, bringing with him today a deep expertise in cross-cultural resolution. Patrick, please join us. And Patrick, just as an aside, I am from the other place, but I promise to be unbiased today. Next, we have Ms. Mehak Oberoi, who is a seasoned legal strategist with 17 plus years of experience in negotiation, risk mitigation, commercial contracts, and dispute resolution across the Asia-Pacific region. She leads the legal function for GE Vernova's hydropower business in APAC, driving legal strategy, compliance, and business-aligned dispute management in complex renewable energy projects. Mehak, please join us. And last but not least, Mr. Rajiv Malik. He's a seasoned in-house legal professional with qualifications in law and company secretarial practice and expertise in cyber law, arbitration, commercial disputes, and IP rights. Recognized as the General Counsel of the Year Consumer, Mr. Malik is also a thought leader at the intersection of law and artificial intelligence with academic exposure to generative AI for lawyers at the IIMA. Rajiv, sir, please join us. I'd like to thank all of you for taking the time out today and joining us for this panel, which I'm sure will be enlightening. Yes, if I ask you to just share those mics. Thank you very much. Let's dive right in with some of the questions that are on most of our minds. And I do encourage you to please be as forthright and candid. And let's try and keep this conversational, because I think the greatest USP of this panel is the wealth of personal experience and industrial knowledge that each of you brings to the topic, and I'd love to hear some of that. Dr. Shastry, I'll start with you, please. We all know the old adage, measure twice, cut once. So when a dispute first arises, what is the first strategic lens through which you choose to assess it? Is it cost exposure, reputational impact, precedent value, leverage, or operational disruption? Or is it something that I've not even thought of to ask you about?
Okay, thanks. Thanks IIRDC and thanks MediateGuru for the opportunity. Pleasure being here. Oh, very rightly said that now disputes are no more a pure play legal domain things. It is more strategical. You're very right there. And very interestingly, you asked that what is the first strategic lens at which anyone looks at the dispute. And that's why the role of GC is slightly different from a pure play lawyer or a pure play legal person. So when a dispute comes, so if I have to say that from a strategic lens, what I will look into. So there were three things I will look into it. First is, as you had said in adage, one more thing is you have to also choose your battles. So that's very important. So if there is a dispute, sometimes the commercial teams, because of whatever reasons is, they will insist that let's go and fight it out. The first thing you have to see overall strategically, whether this is something worth fighting. Is this battle worth having on? Because most of the battles are not worthy enough to be fought. Well, that's the first thing. Second thing is, once you have assured that here there's something which is there in this, there's some meat in this, then comes whether it has to be fought in this turf, in the legal turf, or is there any other operational turf where we should fight it out, where the leverage lies. I'll give an example. Like I'm in infrastructure. I've been in infrastructure for a very long time now. Now, suppose we have an O&M contractor. What we do generally, the road is constructed, then you toll it for 25, 30 years. So there's an EPC contractor for the construction of road, and then there's an O&M contractor for maintaining the road, and then you collect tolls. This is what the basic business model is in the road industry. Now, suppose there's an O&M contractor, and you have a fight with that O&M contractor. And it's a thing which you think, yes, it is a matter whereby you have a very strong legal ground. But you think its matter is small, means from compensation and relation perspective. So that's the first thing that you look into, whether this battle is worth fighting. Now, if you decide that, yes, this is a battle worth fighting, then the second thing is, where is your leverage? Whether you are strong in this legal matter right now, or there are other operational things where you're strong in. Like, for example, you think I'm pretty weak in this legal matter. He has strong documentation here. But then again, I have a leverage in operations with him. He has to do a lot of compliances, and if I really harp more on those compliances, obviously his cost will go up, and all that other stuff, and his cash flow get impacted. If you think that is the way, then this is what you leverage there. That, okay, I'm giving you that benefit there, let's just leave it here, and bring him to the negotiating table, if possible. If you think that your legal leverage is to fight here in this legal turf, you do not have an operational case, or otherwise the legal case is such which impacts your reputation, or otherwise is too important for you, then you fight the legal turf. So that is the second thing you have to decide, that where is the battleground. And then comes the third, is the legal strategy. And what is the ultimate strategy that you want to apply once you have decided that, yes, this matter is big enough, this matter has to be fought on the legal turf. And then comes the thing that, okay, what is the right strategy? Is it an arbitration? Is it a litigation? If it's an arbitration, then what kind of arbitration? What kind of preparation you have to do? And so on and so forth. You have to think it through. In infrastructure, interestingly, and that is what, I don't know, the problem with Indian law, as said, I feel, we take one step forward and two steps backward. In arbitration, we have 1996 law. It was developing slowly and gradually. In past 2.5 decades, we have developed a very robust arbitration framework. But now in infrastructure, they have passed a circular which says that if a matter is more than 10 crores, you have to litigate. Now in infrastructure, when I'm building 1,000 crore piece of road, every single road is 1,000 crore plus, sometimes $1 billion, sometimes $1.5 billion. If that is what my asset size is, my dispute can't be 10 crores. My dispute has to be 100 crores, 200 crores, 500 crores. It has to be $1 million minimum dispute. 10 crores is a very small amount. $1 million is a very small amount.
I think even if you were to try and trigger arbitration for each interim bill,
yes,
even then, you'd be beyond that threshold.
That's what I'm saying. Yeah. So this limit of $1 million of 10 crore rupees is hardly a limit for an infrastructure dispute. So ultimately you have to go to litigation. So I'm saying, so that is where the problem is. But then you have to decide and strategize and what you are supposed to do. So this is how I have to see the strategic lens. These are three things how we'll approach it. Whether it's good enough matter, big enough matter, which turf to fight, and then what is the strategy.
Just to add on
please,
here,
please,
so
yes.
Whenever we are talking about the dispute is coming, so the first foremost thing is what is the impact on the business actually, right? That is very important. For then we can see that is the amount is less or more, and what kind of financial and the reputation risk is there. But in fact, I have seen the disputes are now becoming more of the business instead of a legal.
I think thank you for our panelists for pointing out just how much more difficult your job is compared to a normal, I think, litigating practitioner like myself, because it really seems like the boardroom is often a war room, and as generals, you have to look at it on three different fronts, where I think some of us, but now going from the war room of the generals to perhaps a little bit more of the front lines. I'd like to kick it over to Patrick. Patrick, from your vantage point, because I think we've specifically looked at, and Sir, Dr. Shastri's pointed out some of the factors that go into whether or not to litigate, whether or not to pursue a specific form of dispute resolution. From your vantage point, where do some of these factors originate? Particularly, I think what's very relevant for India is delays. Do you see that these are ploys by parties? Is it the culture of the council in a particular jurisdiction, procedural complexity, or perhaps some immaturity or civil court hang-ups by the tribunals. How can we address one of the greatest issues of alternate dispute resolution in India, which is the lack of efficacy and speed?
Thank you for the question. Great pleasure to be here. Thank you to IIDRC and MediateGuru. So I've had the opportunity, if not the good fortune, to occupy, I think, just about all the roles that we're talking about. From the point of being on boards, being a shareholder client, counsel, arbitrator, and just having an academic relationship to all of those areas. I think that there are just a lot of moving parts in an arbitration or in a litigation or any kind of dispute. Often before it even gets to the point of an arbitration, there are extensive discussions, negotiations. If those break down, often it'll move into a mediation, and that may or may not be successful. And then it really, I think, occupies the attention of the board and shareholders. Some shareholders may also be board members and occupy a dual role or have a double hat, so to speak. And there are definitely meetings prior to commencement of arbitration or receipt of the notice. And then decision whether or not to move forward. So all that really takes time. I don't see that there's a lot of game playing and delays. Often with boards, you're dealing with people who are well established in business or law or some other field, and they can be in various parts of the world. So there's scheduling issues there. Once you do get into an arbitration, you could have one or more counsel, it could be multiple parties. So you have scheduling of parties, counsel. Ultimately, if there is a notice filed, then in an institutional arbitration, you have timelines. There's strict rules, procedure, and so forth. But even with those in place, as compared to an ad hoc arbitration, typically you can see the whole process from start to finish take anywhere from 6, 9, 12, 18 months from beginning to end. More on the average of 8 or 12 to 16 months. And then there's a lot going on during the proceedings. There's of course, the exchange of the claim, the response, counterclaims, appointments, formation of the tribunal, early meetings, scheduling, procedural orders, discovery, document productions, witness statements, expert witness statements, and then the hearing itself. So all of that, you can just see just from a brief outline, there's an enormous amount of things that happen. And from, I think, just about the professional standpoint, it moves quickly, and it seems to move quickly, and especially if you have a caseload and if you have other obligations. From the layperson's perspective, it may seem like a very, very long, drawn-out process. But I think, just to answer the question, it's really a combination of all those factors.
So just a quick follow-up. So then do you think one key factor is that we don't have enough talent? Is it a question of supply and demand? Are professionals, the key professionals who are accessible or available, do they have too much on their plate to be able to dedicate enough time to streamline the process?
Well, being from the other place, I always think there's a lot of talent. Yeah, it's really, I think, a question of matching, alignment, the right persons for the job, for the issue, for what's going on, and assembling those people, the logistics of scheduling. So I don't really think it's a lack of talent. I think it's just really a scheduling and a logistic, sometimes nightmare to get everything together and to make everything work and to proceed in an orderly fashion.
Thank you so much. Mehak, I'm going to jump over to you. I'm going to shift focus a little bit from litigation strategy to talk a little bit more what is slightly, I think, underexplored in India, although we've shown a renewed commitment to it in the last few years, which is mediation. Now, at what stage does mediation realistically become an option in the boardroom? When do we really start exploring settlement? Is mediation viewed internally as a strategic tool, or very often, certainly I'll admit as a litigating lawyer, as a sign of weakness? Does it seem like if we go to the table, it's almost like an admission that we can't beat you?
As far as settlement is concerned, I don't think GCs wake up in the morning and decide that, okay, let's settle today. It's not a mood, it's a risk calculation that we're doing. And there's a lot that's dependent on it. Like Fahim was saying, you're not thinking about can you win? What you're thinking about is what it actually means to win. Whether it is timing, or it's money, or it is project margin slippage, or it is the resources that you're going to use during the process within the company, or it is the long-term relationship with the customer that you're looking at across the globe. I mean, it depends. Multiple bids in the pipeline, it could be a supplier, there are multiple things to it. So the moment the uncertainty becomes more expensive and it starts distorting your balance sheet is when you will look at settlement seriously. Just to give a small example, I mean, in infra projects or renewable projects, if I have liquidated damages that are showing up in my quarterly reports, and I think I have a valid extension of time claim, but because it's showing up in my quarterly reports, I have exposure, I may start thinking of a settlement because I don't think I can wait that long through a dispute to win that over, because my cash crunch is way too much. So I think that's where it depends. And two, when you're talking about mediation being seen as a sign of weakness, no, I don't think so. I think arbitration and litigation are tools of dispute resolution, and so is mediation. So actually, if you're not using the right tool, then it's not a sign of strength, it is inefficiency. And I think one of the biggest advantages of mediation, which I feel many people miss, is the fact that it shows you reality in your face. It tells you how weak you are, how much of water you are under at that point of time. I mean, people talk about timing and settlement and relationships. All of that is true. But the way it shows you the mirror is unfathomable. And that's the reason why people should go into mediation. If at all, if you don't settle, you'll just build a better case in arbitration.
Please, yeah.
So just to add thing, that mediation, although we are not talking about the mediation, but in India, mediation is not a new concept, and it cannot be a weakness in any ways, because it was the Mahabharata time, the Lord Krishna has had the unsuccessful mediation that taught us that when that unsuccessful what happens, and it happens in translated into the Mahabharata, right? So that is the background of that. And in fact, previously also, the lot of Mahajans, Panchayats are there, which are having the mediation thing in place, and which worked very well actually. And I think that is the right time to have the mediation or the settlement is when it is being crystallized, right? And it should not that we delay too much, that the relations are not that we can mediate.
I think Dr. Malik has given us a great point. Maybe as a culture, we need to rediscover the power of mediation.
All depends on the mediator. That plays a very important role, and that is where we feel in India we lack that professionals. And maybe that is one thing where people should, if somebody is listening, mediation as a career.
Because we don't have too many trained mediators yet. So everyone thinks of it as a process that, you know, you get two parties in the room and you get them to talk. There is so much of time that goes into breaking the ice with the parties, and how you generally need to extract their interests versus what their positions actually are. There's so much more to it. And I don't think you can appreciate it unless you go through that training.
I think Dr. Shastry and Mehak, you've raised a really good point about this. It's the presence and qualifications of the mediators. On that point, I want to throw back, Mehak, one follow-up question. Do you think arbitrators should play a greater role in mediation? And because this is, I think it's a bit of a divisive stand that I've seen in personal experience in academic discussions in India. On the one hand, there seems to be a fear of arbitrator bias then being used in a potential 34. So what do you think of this?
I don't think it's a hardcore no. I think they can, but it has to be used very carefully. They cannot engineer it. They cannot pressure it. They can subtly encourage it. And I think a couple of places, whilst the process of arbitration is going on, where it can probably be explored is probably at the time after submission of the pleadings or after document production. You probably just throw that one question at the party saying that, okay, out of the 10 issues that you have, what is it according to you, those 2 that drive up the value really as far as this dispute is concerned? So I think that in itself reframes the question and opens the door for settlement. That is one. And I think 2 would be possibly just to incorporate in those arbitration timelines somewhere one commercial dialogue. So it just creates a structured space to talk of something more. And for that, the arbitrator doesn't necessarily need to be there for that discussion. But the fact that you just create that structured space for the parties to have a commercial dialogue, because the deeper you go into the proceedings, I think both parties then have a sense of where the dispute is really headed. So I think, yeah. But I'm sure Patrick is the right person to...
And that's exactly who I was about to throw over to. Yes. Have you had personal experience with this idea of the arbitrator actively encouraging mediation, or as Mehak is very, I would say, very sharply suggested, structuring a space for mediation without necessarily acting as a mediator?
I think structuring the space, that tends to be my experience. And also, I think being too much of an advocate can sort of impinge on your lack of impartiality or the appearance of impartiality. And so I think what parties are looking for are intellect and integrity. And so I don't think either one guarantees the other. So I think it's important to try to create the space. I think that it's a very powerful tool, ARB, or just introduction of a mediation during the course of the proceedings, just to mention it, create the space, and then you've planted the seeds, and then it's really up to the parties. That's my take.
Right. Please.
From one of the justices that they were doing one arbitration. He was doing one arbitration, and they wrapped up everything. He wrote the award. He came to the session with the award, and all he said was, "The award is in my hands. Do you want me to open it, or do you want to give yourself another shot at?" And the parties did settle. They didn't see the award. So
I've been in a somewhat similar situation. We didn't get quite as far as the award being written, but after final arguments, I think the arbitrator just stopped. He summed up both of our arguments as he understood them, said that he was still going to look at our written submissions, and then we did go back to the settlement. Unfortunately, we didn't end up settling, but we did go back for one last attempt. And I think what was particularly important about that arbitration was, and why we at least thought about settlement, even at such an advanced stage, was that one of the parties was an MSME. And for them, the idea of protracting that by considering a 34 challenge, arbitrating again, was almost unfathomable. And on that, I'm going to throw over to Mr. Malik.
Before that, I just want to add here that it is good that we are. That's the same thing I was about to say actually, which you said, right? So it's a good thing that we are proceeding towards thinking about mediation right now. Few years back, when you search in Google you will not find mediation there, you will find meditation there. So that was the scenario, right? So it's a good scenario now has been changed.
And I think, but let's not discount that. I think perhaps some of us should meditate before we go to mediate.
I do that.
You do.
And I have got benefited because of that also.
I think, yeah, I think centering yourself, that probably plays a key role. But I'm going to throw to you a question about arbitration. Now, talking about arbitration, does today arbitration meaningfully serve MSMEs? Now, I think MSMEs are amongst the key demographic that can benefit from structured and efficacious ADR mechanisms. In your opinion, have you seen from your experience that is actually fulfilling that role for MSMEs in India and smaller commercial players? Or has it become the playing ground of people with deeper pockets and the power to take a longer fight?
No, it's the other way around actually. Here, under the MSME Act, when the conciliation and arbitration is going on, it is totally in favor of MSME, not in the favor of the large companies. In fact, you know that how much the interest is there, and you are sitting in Delhi, so we can presume that everything is okay. But I have to deal with the different MSME forums. First of all, these views are my personal, not of my company, right? And I'm not criticizing anyone. But the infrastructure which I have seen with the MSMEs, and in fact, without going into the details of the cases, the order has been passed in the favor of MSME only. So it is the other way around. It's not that in the normal arbitration I can understand, but in that scenario, I think it's tilted towards the MSME, and it's not a good thing. I think this kind of institution should be there, where the both parties should be have a set of rules, and the proper deliberation is there on the concept, and then the decision should come out.
You think that perhaps because of the specialist legislation, there's almost an overcorrection?
Yes, because you can't take them to the court and other things. Even if they are having some of the fraudulent activity and they're submitting the bills, then they are pressurizing the other way around.
So there are two things here. One is the MSME. So you have to segregate between micro, small, and the medium enterprise separately. For micro, small, there is a specific forum under the MSME Act itself. As Rajiv has said, and yes, they can use it. But you see in practice, and that's why I want in law firms and lawyers to really do all these studies. I heard somewhere that now AI is going to create more billionaires next 5 years than what internet could do in last 20 years. I heard somewhere someone saying that. But in legal field, I feel it is even more required. And now with all these AIs and generative AI tools, ODR platform, I heard the IIDRC's CLO saying about the ODR platform they have. So now is the time actually which we really invest in these things, and for all these smaller players, because the biggest problem is, as even Mehak and Rajiv both highlighted, in India, it's about the cash flow issue. I know even if I have a right case to fight, I cannot spend 10 years or 5 years or 7 years end to end, because I will die by the time money will come. If I need food today, I need the food today, not after 5 days. So that is the biggest problem in India, and that's why that solution is required. Maybe mediation is a very good solution. We need good mediators and good platforms who can really solve these issues. Most of the cases, they don't go to court or arbitration at all because of these reasons. And despite that, we have a huge pendency. We have almost 5 crore cases pending. So you can understand that what kind of solution is, there's a big problem there, and a solution has to come out from lawyers and law firms. And that's why instead of chasing the big GCs like Rajiv and Mehak, lawyers should really think a business model there because they have limited capacity to do, and it's an untapped model. Just my thoughts.
No, I think that's a wonderful point, and I think that is generally a larger question I'd love to throw over to the panel before we open it up for questions from the audience. What would each of you would say is something specific that we need to address about the culture of litigation or ADR in India?
I think we should move towards the ODR. That is better.
More of a shift from physical to digital or virtual.
At least for the smaller cases where there is no much of stake is there, so we can settle it faster.
Sector-specific expertise. I think that's completely missing at this point in time.
I like the idea of mandatory arbitration, not arbitration, but mediation, where the parties have to mediate, not necessarily settle, And I think that's a trend that we're seeing in legislation and in other parts of the world.
One mindset change maybe of people is that we should have good arbitrators, not only retired judges. Again, I heard this from some conversation. That is, now the time has come. Let's have specialist arbitrators and specialist mediators. Gone is the time that we simply have a name that doesn't work nowadays. So let's go for specialists.
So arbitration should not be treated as a legal event. It should be treated as a business event, actually.
I say this fully aware that I'm a litigating lawyer who also does arbitration, but I 100% agree. I'm more than happy to call out the legal practitioners, the lawyers, for bringing a few bad courtroom habits into the arbitration practice that I definitely think we need to move away from. And I think Sir has summed it up very well by saying we can't look at the arbitration proceedings as a purely legal, as a legal practice. That needs to be more of a business-oriented proceeding. You wanted to add? Well, I don't think that I should hog the panelists, all of the panelists' time, and I think we do have an interested audience here. If anybody would like to ask a question, please do throw your hand up. Feel free to give a very, very quick, brief introduction of yourself before you ask your question, and I do hope that it'll be a question so that you can get the best out of our panel here. Anybody who's interested? Please, yes.
Good afternoon, everyone. My name is Joe Torrado. I'm an international arbitrator and mediator based in London. It's more of an observation, but I hope it's going to be a provocative one because I wanted to push back very strongly on the concept of mediation denoting weakness. I think actually the opposite is completely true. And what you have seen, there are many multinationals that would actually publicly put on their websites that our policy is to deal with disputes by mediation as a preliminary step before. And so I think for all the reasons that we've heard from our panel about the advantages of mediation, in particular the certainty that mediation gives you that any litigation arbitration doesn't, there's always an element of lottery. And I think that actually shows an element of confidence and strength, because actually what you're trying to get is a resolution that meets your strategic interests as a company, that is, whether that's saving costs or reputational issues. And I think this is part of the problem. There is a perception issue about mediation and being soft, not really for serious commercial disputes. And a very strong advocate, Patrick's heard me say this several times already, quite the opposite. I think mediation gives you a solution that no litigation or arbitration can do, and the ability to create creative resolutions that not only may resolve the actual current dispute between the parties, but potential pending disputes in the sidelines, and maybe even disputes you don't even know are coming down the line, is an amazing advantage of mediation. But I totally agree with Mehak, when she's saying it's to be seen as a tool. It's not a panacea. You shouldn't oversell mediation, but equally, I think there's a danger. We have traditionally undersold mediation. So, with due respect, I push back strongly, and I become ever more, I think, an advocate for the benefits of mediation. So, I just wanted to share that.
I'm quite happy my statement provoked such a provocative statement. Yes, sir, you have a question.
Yes, so I am. My name is Prashant Kumar. I am a partner at Dua Associates. So, first of all, very enlightening session. I have a question as regards multi-tier dispute resolution clause. Now, a lot of times corporate team takes our help in drafting clauses. So they will introduce mediation, they will introduce conciliation and arbitration. So, what's your views on these kind of clauses? Does this really help in practice? So that's my question is.
I think that's a great question. Anyone from the panel who wants to jump in on that?
If I can share my experience, you're right, but what happens practically, if you're going for a fight for arbitration or any legal dispute, this means all the channels of negotiation are already failed. Because generally it is the chairman of this company, chairman of that company, if the dispute is worthy enough, they would have met and they would have decided, no, let's just decide in the battleground. So if that is the case, even you have this multi-tier clauses, ultimately it will go to the final dispute resolution only. And you need a final order, a complete adversarial order. But sometimes what happens is in that process, if you have these clauses, sometimes their egos are there initially, but when you are into the process, and as like rightly said, when you are into it and you are finding it out and then you are writing down all those things, okay, I have these 10 points, we have these 10 points. Maybe on some of those actually, at least these multi-tier can narrow it down, at least the arbitration. That it may help in that sense. Otherwise, in my better experience, it always led to a dispute, and these multi-tier have only delayed the dispute rather than anything.
See, at least you have a process in place so that in case you have to invoke something, you have something to rely upon.
Yeah, the 30 days and again 60 days, something like that. So sometimes they're just a paper formality mostly, but sometimes it may help actually. In my practice, mostly it has not. It has fought, we have fought ultimately, but there can be some cases here and there.
Thank you.
I think it's worth keeping them in because it creates at least the opportunity that the parties that who were eventually going to fight may change their minds. But I think you're right. If they're not going to change their minds, then we're going to go through it. Fait accompli.
If you've decided to spend 3 years in arbitration, I'm sure you can spend 30 days before that if something can work.
But it's generally the ego issue at the starting point, and then it becomes very
A
difficult.
trained
So that's
mediator
why.
will be able to break through that ego. Yeah.
That's definitely one of the key reasons that we need to at least give ourselves the space and the opportunity.
Even a mediator, MEDARB rules are there with the institutions. A mediator can act as an arbitrator also. Our act doesn't permit that, the Mediation Act 23, so it doesn't permit. But in Canada and certain other countries, CIEC has got different rules. MEDARB rules are there. But only thing is that in Canada it is permitted. UK it is not permitted. USA it is permitted in some states. So as far as gentleman is asking from Dua and company, MEDARB and even MEDARB and MEDBAC, they have been very, very successful in Canada. I mean, in cross-border, I have done mediation with Chinese companies, and I have had wonderful results. Wonderful results. My clients, they used to go to Chinese factories, look at the sample, quality A. When it is dispatched, it reaches Bangalore, they find the batteries are quality B when it is tested in the laboratory. By the time the LC has been paid and the dispute starts. And most of the things they refer to us for mediation, it is very, very successful. Even those cases in India which have gone to NCLT and they are mediated and done very well, cross-border.
I think
the mediator is somebody who is not adversarial, arbitrator is adversarial, and that's why they've kept that distinction. So we do not have the same person as mediator and arbitrator.
Maybe that is a mindset. When we do LLB, that mindset is there. Because till now, mediation was not a part of the curriculum in LLB. Maybe that mindset will come now. And second thing, what you gentlemen said about AI and those things, I was active part of the DAO in November in Delhi, where in fact, I met you there also in Taj. And then what happened was the entire bottom line was that whatever, there were 6 justices from Supreme Court and more than 6 chief justices from the High Court. The bottom line was that ChatGPT and Gen AI, they are like what we call in Hindi, the kunji or the payment books which are sold in front of Regal Theatre before the exams, where you get 10 top questions. Exactly. So please, and in fact, like a cigarette pack, it is harmful for the health. ChatGPT is harmful for all of us sitting here. I tell you very frankly, don't use it.
I think I really appreciate that comment and Dr. Shastri's intervention, because I think what definitely we see is that it is culture.
And what I recommend, I have done it myself. I have my expertise, the vertical in Industry 4.0. I've had industry training at Düsseldorf during. And there, what is called Industry 4.0 consists of 4 things: data analytics, IoT, blockchain, and AI. AI has got 3 components: DL, ML, and AI. Now, what we are talking about, as all wearing black coats, we know what is a contract. And what is blockchain is a digital contract. Let us promote that. In Bahrain government was given an award at Davos that
So
entire banking industry has gone into blockchain.
I apologize. We'll just ask you to quickly some of your point, because I think there's a lady behind you also has a question. I'd love to
We
hear
should.
from you.
My question is that we should promote blockchain as yeah, exactly.
Fair.
Thank you. Yeah. So, sir, I think blockchain is used mostly for the smart contracts and all things in India. It's doing that. And I had only objection regarding your chat GPT, because I'm in big favor of generative AI. Because how do you use it? What prompts you give? Like even yesterday, there was a comment by the Chief Justice regarding an arbitration clause that was drafted long back before the generative AI was there. So it is actually how do you prepare it, how do you do it, and if you just use chat gpt as a Google, then it is definitely going to give you errors, and all hallucinations will be there. But the question that I wanted to ask the panel is, how optimistic are we about ADR in India? Because as an active practitioner in Supreme Court, whatever I see is that whether you go for mediation or arbitration, ultimately it lands in courts. So why do we waste so much of a time? In other jurisdictions, I know that it is doing fantastically well. Maybe for big commercial arbitrations and mediation, it is doing fantastically well. Like if you talk about Lodha dispute or recent some more big dispute. But for generally speaking, I don't see it working on ground. Your thoughts?
So I genuinely think that we should not be using the term ADR anymore. It is not an alternate dispute resolution method anymore. It is the dispute resolution method. The state currently of the courts is not such to be able to take on more workload at all. I mean, if you were to see the stats, I think more than 37 years ago, the Law Commission had recommended us to double our judges per million. And that time we had 21 per million. Today also we have 21 per million. And if you were to compare it to other countries, Germany has 240 per million. United States has around 150. So plus the Niti Aayog, I think it's a couple of years old, right? Which said that it would take 342 years for you to wrap up the backlog without any fresh cases coming in. So that mindset needs to change. This is the dispute resolution forum that you need to invoke. Yes, the issue would come as far as enforcement, but in enforcement as well, I think things have become better. We're still in transition. I'm not saying they're the best yet, but it will get better. If you're going to rely on courts alone, then you're not going anywhere. And that's just the sad reality that we are facing today. We may as well accept it and take the course that is most feasible at this point of time, or rather viable.
Yeah, I agree with you, Mehak, but again, that is coming like a round circle. We go for the alternative and again we are coming to the courts. There has to be some check there. Like even when we made the specialized tribunals, still you are coming. Like I remember the first case on IBC, it ultimately came down to principles of natural justice, or Supreme Court taking over all the infrastructure matters. So I think there has to be some sort of a discipline, and then docket management, I think, is what we require at the
I
judges.
absolutely agree. Checks and balances have to be there. Yes, I agree with arbitration also. We've been a little inconsistent in terms of the message that we are trying to set forth globally.
Yeah.
But those checks and balances don't mean you move from ADR altogether.
No, that is, I'm saying, not move, but perhaps we should have a law that we need to stop at somewhere. Like we don't get the same respect that SIAC or LCIA is getting. I think the basic problem we are having is our ethical standards. I think Patrick will agree
The
with
problem is not the law. The problem is the shifting jurisprudence that we have.
I think Dr. Shastry summed it up really, really well when he said we're very often doing 2 steps forward, 1 step. Any other questions? I think, okay, we've got a hand up in the back.
I am a senior counsel from Delhi High Court, Vibha Mahajan. I have also presided over many arbitrations as a sole arbitrator. And I don't have a very good experience so far as the mediation is concerned in India. I'm talking about in specific. And my question is to Ms. Oberoi, specifically. So in cases where in most of the commercial litigations, we have seen that one of the parties, they go and secure an ex parte injunction order against the other party. Now, in those cases, when the matters are referred to mediation, you don't see an equal bargaining power. And how the role of a mediator, do you think, can you actually persuade the party which has obtained an injunction order to come to some terms, reduce its bargaining power, come down, and then settle with the other party? Because I don't see that happening. Because in India, the matters are prolonged for a very long time. Once an injunction order is taken, obviously, it goes in your favor. Why would you want to settle the matter? You would want the other party to come to terms what you basically want. So how, as a mediator, do you think in such situation you would act, or what is the role of a mediator in such situations? That is basically I want to know.
Very thought-provoking question, and equally extremely difficult for the mediator to handle as well. But the mediators are specifically trained for these kind of situations. There are mock sessions that are conducted to have breakthroughs of these sorts. There is no doubt about the fact that the party who took the injunction has the upper hand. But then eventually, when you're sitting with the mediator, the questions that are asked to the parties is what is relevant. So even if they've obtained an injunction, what is it that is their end goal? The means is the injunction. The injunction cannot be the end goal. So what is it that they actually want to achieve eventually out of this dispute? That is the first question to ask. So if the mediator asks the right questions, they will always be able to get the correct answers, which will help you be able to extract what is the actual interest of the party in the particular dispute. So I would only say that the right questions, which are difficult to frame, but if you get those right, you'll make a breakthrough.
Yes, please. I concur the sentiment of our audience, because I think as we all dealt with that situation, and it can be problematic, and I think you've given a very good perspective how the mediator needs to reset the clock essentially and give the parties a level playing field to have that conversation. So yes.
Good evening. I'm Advocate Zaria Brizvi. I also am a mediator and an arbitrator. A small question which I have. Thank you for having a wonderful panel and the institution. Thanks to all of you. My question is with respect to the institutional integrity of institutional arbitrations. Because many a times with some of the ODR platforms and others with whom I've been associated, I've seen that they're more inclined towards the regular clients rather than people. So something I'll not give my any opinions, would want to hear about how do we maintain institutional integrity while dealing with maybe bulk clients and things like that. Thank you.
I think this is a very good question. And we see this very often. Yeah. Appointment bias. Something we haven't yet quite addressed is appointment bias. Yeah. I would love to hear how the GCs deal with this question.
No, but then this is, so it's like a business reality of any capitalistic society. As well as that, because they are private institutions and they are your clients. So the biggest client, you get the biggest of the priorities. So this is one thing. But nonetheless, that alone itself doesn't create bias as long as those services are really good. The problem is, and that is what I was referring to, that why are we not like CIAC or LTIE or others? And despite Indian lawyers going and arguing, Indian brain going and arguing in Singapore and London and other places, why India is not a hub? I feel two things there. One is obviously our mindset of going to court very regularly, and obviously one part want to delay things. So obviously it is incentivized to go to court and delay it. And second is the institutional arbitration right now do not have that meat enough to really resolve things quicker and faster. Because like if I go to CIAC, I can check precedents. Okay, this is the case, and this is what the arbitrators are. In Indian arbitration centers, that is not yet there. But maybe it's very, very nuanced, very, what you call, baby step right now we're taking, and maybe in coming times we'll have to this level whereby we'll have stronger institutional arbitrators. We have the right talent here. But what I feel is like infrastructure, as I said, for me now, anything about 10 crore rupees, government doesn't allow me to arbitrate. I do a litigator. All these steps at times create an environment whereby bulk of the clients will go and flood the courts. And I agree with Mehak that now we have to think on all these alternate dispute resolution systems. We really strengthen it. And this is what my thoughts are. So that's what the answer is, that institute arbitration still have to come up in India. And I don't find anything bias they are serving a bulk.
And I think we all look forward to seeing how our hosts will contribute to the growth of You may, sir, but I will insist that it's a question. Yes, please.
Thank you, sir. Sir, my question is regarding the 2025 Amendment Act, which has come in UK. What has happened is that most of the institutions haven't changed their rules as yet. My clients who were exporting rice or some agriculture commodities, kafta and others, they're still, even the digital signatures or even e-bill of lading. So how do we deal with all those things now? The Act doesn't talk about digital signature. It doesn't talk about anything about IT, even though it has been amended after 1996 to 20. It has taken 9 years to come. But still, it is not that, I would be very frank to say, please don't mind, it's not that forward-looking amendment which have come.
You're talking about the
Because my clients are really suffering going to GAFTA and others.
A lot of it's the same. I haven't seen really big changes. So I think perhaps it's yes. So it's still an issue.
One last
quick question, quick answer. I love it. We'll take one last. Yes.
So, yeah.
Good evening. I'm Surjendu Shankar Das. I practice arbitration and courts as well, Supreme Court and High Court. My question to the panelists, especially the GCs, in a given case, any claim comes to you, it could be you could be also claimant. What would be 3 determining criteria or factors in your mind to opt for or negotiate settlement, mediate or conciliate instead of going for a long battle of arbitration? 3 main criteria as a GC, what you see in that particular dispute or claim that should be determining factor. That's one question. Second question, would you opt for it in the beginning when you have the claim in hand, or wait for the disclosure documents, something in your hand, and to sort of evaluate and opt for settlement, mediation, conciliation, whatever it is? So these 2 questions.
I'll take that. So, the discussion about how to close out on a dispute starts much sooner than you'd imagine within a company. So a couple of things that one would consider while figuring out whether you should go claim the amount in court or arbitration, or would you want to mediate or just settle it up front, sitting across the table. One would be 3 categories of amounts that you'd come up with: your best likely scenario, your worst likely scenario, and your most probable scenario. So you will have 3 figures, okay? Those 3 figures are typically backed by internal analysis, which would be your whatever documentation you may have, the people who are there to support as fact witnesses, etc. And of course, the contractual analysis. Then that is one. Then the second factor would be your NPV analysis, which is that if I was to spend 2 million today to get 10 million 3 years later, if I was to get hypothetically 7 million in settlement today, then I think I'm good to go. If they're willing to settle at 7, which would be 10 3 years later, I'm okay. So you do that discounting NPV analysis. That is 2. So actually, it is really just about the numbers and nothing else.
Rajiv, yes, actually, I'd love to hear your perspective on this, specifically legal leader, LG, coming from particularly a consumer company perspective. I think I'd really love to hear your views on this.
First of all, 3 things he has told. So first thing is the impact on the business, right, and whether it can be set as a precedent or not. And second thing, the reputation of our brand. And third thing is the cost. So three things are very important in that case while we are deciding. And of course, the vendors, because we always treat as our, if you are talking of the consumer cases, that is a very small cases, right? We always treat it as a consumer as a god. So it will turn up that he will be ending up buying the more products. So we tend to settle it instead of fighting it. It's for the, just for the consumer, I'm saying. And
As a consumer,
as a consumer, I'm saying.
As a consumer, I absolutely agree. I think a fair resolution to consumer probably is a drop in the ocean for a company, but it's consumer brand loyalty, I think, is the prize for that cost. So I would just now love for our panelists to just share some brief concluding thoughts. Malik, we'll start on this side this time. We'll start with you. You would like? All right, okay. So, the man wants the last word. I'm happy to give it to him.
He'll end with a poem. yeah. So
I think so. Sorry, your brief thoughts on the discussion that we've had today, and in your mind, from listening to your fellow panelists, what's your key takeaway that you'd like to share with our audience today?
Yeah, sure. So I'll 2-3 things I'll share. One is, as though we should not use ChatGPT, etc. But I feel AI is something which is the future, and better you master it earlier, it is better. How you master it is different, but you have to tackle that beast. Secondly, so far as one question that this gentleman asked regarding as to what you decide, the second part of his question, that okay, what will you decide once you have seen some papers or some evidences, will you change your study? Yes, definitely we change courses at times, because if the dispute is 3 years long, things may change. Initially, obviously Mehak and Rajiv have already said that what is the thought process to start, but sometime in between also keep on changing because of the variety of things. And lastly, the concluding thought for the day is, as I said, legal nowadays is a very important, but it's a tool only. In a business scenario as a GC, you have to think legal solutions as whether it be arbitration, whether it be litigation, or anything else, or mediation. It is just one of the tools in your hand. You have other things. You have to see where your leverage is. So you have to choose your battlegrounds well. Sometimes the battlegrounds are in the courtrooms or in the dispute resolution. Sometimes the battlegrounds are not in the dispute resolution. That call a GC has to take. And that's why you have to now slowly evolve from a pure play lawyer to a GC. And that is where the difference is. That you have now the one, you are a warrior who is not simply, you are a general, not simply a warrior going and fighting things. You are the one who will strategize. So that is a skill set that you will develop. And that depends industry-wise. Infrastructure may be very different. Consumer it may be very different. For some other industry it may be very, very different. So that's what my concluding thoughts are.
Thank you. I think it was a great discussion. I still think ADR or DR is now calling it is still the way. Early evaluation, I believe, is critical. Having worn all the hats in the organization as a lawyer, party, and so forth, I think it really behooves you strategically and tactically to look at mediation first, arbitration perhaps second, and think about settlement throughout the entire process. As a litigator, trial lawyer, we looked at mediation from beginning to end, even post-judgment. So there's always an opportunity, there's a place for it. I think it needs strategic evaluation, looking at the numbers, looking at the parties, evaluating the risk, the outcomes, risk versus return. And just getting on with what you do, how you make your money, moving away from litigation to perhaps producing a product or what have you. So I think there's enormous benefit. There's a lot to be done, recognition and enforcement. Do we need legislative fixes? Perhaps, but it's certainly a work in progress. And I think we've made a lot of progress in the past 30 years, at least in the U.S., and we're seeing it internationally.
I actually don't think I have anything more to say. I've pretty much said it all. I think maybe just to conclude on what a GC's role would be, I think that was really the topic, right? Inside the boardroom. Yeah. So I think we're no more sitting in ivory towers and issuing academic opinions. We're pretty much sitting in that boardroom, taking those calls with the business, and most of the time with incomplete facts. And I think that's the toughest. And that's why when we talk about all sorts of impacts and analysis that we do, that's the only way we have to be able to extract maximum information from the business, because the business is way too close to the dispute to be able to come and say, there's no meat, don't fight it. So, yeah.
So when I was thinking of this topic, right, so I have penned certain thoughts, right? So they are a little bit longer, so please bear with me for that, right? So it is saying the cost of being right. When did a dispute stop being about principle and become a test of patience and persistence? Was it when the first legal invoice arrived? Quiet, clinical, cumulative. Each page a reminder that conflict carries consequence. Or when hearing stretched like corridors with no visible doors, date after date, promise after more. Was it when management stopped asking, are we right? And began asking, how long? How much more to endure? When did the cost grew heavier than claim? Was it when files multiplied, memories faded, and certainty once firm no longer felt the same? Was that the moment? And when the award finally came, measured, reasoned, formally framed, did it feel like victory claimed or simply relief obtained? Because an award in our system can be a lighthouse in fog, steady in light, yet distant from shore. Execution follows, challenges follows, delays follows. A cycle of contest and counter contest, of right declared but relief deferred. A right declared is not always a right delivered. Somewhere between claim and recovery, between assertion and actualization, enthusiasm turned into endurance, confidence into conscious assurances. No one celebrates commercial conflict. There is calculation, there is containment, there is cost, financial strain, management bandwidth, market drift. Reputation does not shatter in sound, it erodes subtle and slow, quietly worn down. So perhaps the deeper question is not whether arbitration succeeds, but when governance proceeds, at dispute, at notice, at award, or earlier, in contracts crafted with care, in risk reviewed before they flare, before positions hardened and patience becomes the price we bear. Because sometimes the strongest control is not exercised in argument, but in anticipation. And the real victory in commercial conflict is not the award we enforce, but the explanation we foresee and prevent before it takes its course, Thank you. Thank you so much.
I think that, sir, you brought us full circle. We started from the boardroom to the war room, and now we're ending with some very wise words from our own warrior philosopher, our own Sun Tzu. I'd really like to thank our panel for a wonderful discussion today and some very key insights that I think that we can all really, we've all been enlightened with. But before we conclude, I'd love to invite our representative from IIDRC.
Yeah, so I'll just take the advantage of being the host today, and just because we're talking about inside the boardroom, the General Counsel's playbook, this question is to the General Counsels here. Because my question is from an institutional perspective. Although there are not much institutional matters that you must be dealing with, ad hoc matters would be more. But we would like to know how the institutions can play a role in facilitating big corporations and businesses in dealing with these arbitrations, first. Second, what are the considerations that are taken by GCs while narrowing down which institution they would like to prefer? So that's a very question that
Fahim is that student in class when the teacher's about to leave the class. Like, "Nee, par aapne homework nahi diya."
You have already heard the pain through my thoughts, right? So, and you are the future actually. The institutions are the future. Ad hoc is not going to stay there. I don't think so. I don't know. You may differ. My panelists may differ, but I see as institutions, because they will be having a certain set of rules where the transparency is there, integrity is there, and that can be a real benefit for all. And because they should have that infrastructure also for example, having the ADRs, the online dispute resolutions also. So I personally believe that's the future, that's going to the future.
And if I can share my thoughts, one is, see, India right now is $4 trillion economy, and we presume that it's going to become a 10 trillion in few years, 20 trillion sometimes, because it is bound, because we are the youngest demographic. So this is something which, if we take the right step, is going to go up. Bigger economy means bigger disputes, more disputes. Because ultimately, we need someone to settle things. We'll always disagree. There will be conflict, there will be disagreement on the contractual clauses. So we need someone to settle our disputes. Now, what are the options? One is we have courts. Fortunately, unfortunately, Indian courts right now, and this will be the situation coming along also, they are overburdened. First of all, they have a lot of policy decisions which they have to take care of. There are a lot of criminal matters which they have to take care of. Bigger size population means they will always be overburdened, and therefore commercial disputes in their scheme of things is always secondary. For me, a 1 crore rupees is a very big thing because it can be my life and death. But that 1 crore rupees civil dispute for a judge who's handling all these murders and rapes and constitutional policies, for him, that 1 crore rupee dispute is a very minuscule dispute. So obviously, courts will be overburdened with those things. And so ADR is as Mehak said, is the DR now. Now coming is where the IRDCs, forum like IRDC can really, or IIDRC can really help, is where you have to institutionalize this thought. Not only in the bigger firm definitely are quite aware. They are skeptical because we easily go to SIAC, we easily go to LCIE. I don't even think twice when I'm signing on a SIAC arbitration clause. But I will think twice, 10 times I have to sign a IIDRC clause. So that is where, that is the gap which has to be bridged, and that can't be bridged suddenly by the top firms. That can be only bridged by delivering results, and where the results are to be driven are these smaller firms. Because if India is becoming from 4 to 10 trillion or 20 trillion, all these smaller firms which are just a 10 crore company today is going to become a 1,000 crore company. That's how India has to grow. So if you can catch and tie up with that 10 crore company today and can show your benefit to that client today, obviously that is going to stick to the institutional thing. So that is where I feel the real business lies there, and to work on them today, so that in 10 years and decades you can really become a SIAC or an LCIE. That's what my thoughts are.
No, I think I definitely agree with Dr. Shastry. I think I'm going to stick to the same point that it depends a lot on the pool of arbitrators that you would have. My field is very technical in nature, so unless I have confidence in the expertise of the pool of arbitrators you have, I wouldn't give it a go.
Thank you so much. Thank you so much. I think very enlightening points for an institution to hear, and I think we'll certainly work on those points. Thank you.
I think that's it, and I'd like to thank once again our panelists, and I'd really like to thank our audience who patiently listened to us, and we hope that you've taken away some nuggets of wisdom, because I definitely have.
Moderator, fantastic job, Zafar, and a great audience. I was really enlightened to have this interaction with such an interactive audience. Thank you so much. Very engaging. Thanks.
Thank you. Well, thanks all around. And I'll take the opportunity one last time to thank our hosts, IIDRC, for making this happen, and for MediateGuru, of course, who are part of the larger conversations that are happening. It's been our privilege to be a part of that today, and I'll hand it back over to our hosts to finish us off. Thank you so much.